Hey there, folks. Elder Law Care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, today's question is, who gets your stuff if you do not have a will? Or if you have what I refer to as the government plan, which is dying without a will, who gets your stuff? Very interesting, folks. And my recommendation, check with the attorney in your state, in your jurisdiction, because oftentimes these laws of intestate or laws of intestacy are specific to each state. Today I'm going to cover Massachusetts laws of intestate or laws of intestacy on who gets your property, who gets your hard-earned assets if you die here in the Commonwealth of Massachusetts without a will. Very interesting here in the Commonwealth. Most of you would think that, hey, I'm married. If I die, my spouse gets everything, and sadly, your spouse may think the same thing, but it's not always the case, okay? So they have a lot of unique rules with the laws of intestacy. And folks, I have them printed out right here, so I want to go over them with you. Really, really important. So pick up a pen or pencil and your notebook, and you may want to write this down. And if you have any follow-up questions, of course, give us a call or contact us at elderlawcare.com. So let's take a look. If you have the government plan or you do not have a will here in the Commonwealth, this is where your stuff will go. If you die with children but no spouse, here's what happens. Children inherit everything, okay? Pretty straightforward. Children, no spouse, your children will inherit everything. Caveat, caution there, if your children are minors, if they're under 18 years of age, they will not be able to legally get their hands on your property. Someone will have to appoint a conservator to manage their financial assets for them. Things will get tied up in the probate court, what I call the stresses and messes of probate court, or the economic and emotional headaches of probate court. Moving on. If you die with a spouse but no descendants or parents, you die with a spouse, no descendants or children or parents, then your spouse inherits everything. That's the general rule. That's what most people will think happens with the other scenarios as well. But here's where it gets interesting. If you die with a spouse and descendants from you and the spouse, and that spouse has no other descendants and someone other than that spouse, then your spouse inherits everything once again. Spouse and descendants from you, and that spouse and the spouse has no other descendants from anyone else, then your spouse inherits everything. That's your family, husband, wife, and you have children together. Your spouse inherits everything. All right, here's where it really gets interesting, folks. Spouse and descendants from you, and that spouse has descendants from another relationship. So this is like the Brady Bunch a little bit. You and your spouse have children together, but your spouse has children with someone else from a prior relationship. No will. Here's what happens. Your spouse inherits the first $100,000 of your estate plus 1/2 of the balance. Your spouse inherits the first $100,000 of your estate plus 1/2 of the balance. And your descendants inherit 1/2 of your intestate property as well. So your children would get the other half. So your spouse does not get everything like the other scenarios. Your spouse only gets the first $100,000 plus 1/2 of the balance, and then your descendant children get the other half of your property. Gets more interesting. Spouse and descendants from you and someone other than that spouse. Okay, spouse and descendants from you and someone other than that spouse. Again, maybe a second marriage, and you and your spouse, and you have children from a prior relationship or a prior marriage, no will. Here's what happens. Your spouse inherits the first $100,000 of your intestate estate, which is dying without a will, the government plan, and 1/2 of the balance. Your descendants, children, inherit 1/2 of your intestate property. So not only is the assets being what they call bifurcated and split and separated, but from my experience, this usually puts the family on the backside of the cloud, where you have family harm, family disharmony, thunderstorms, here comes the lightning, the rain, family getting soaked. You got World War III in some of these occasions. You got a huge legal tug of war going on now here, where your spouse is maybe the stepmom with your children from the first marriage or relationship, and everyone's in a very precarious situation here. So let's continue here, folks. If you die, spouse and parents, but no descendants. If you have a spouse and you still have maybe elderly parents, but no children, you would think your spouse would get all. Not so. Laws of intestate. Your spouse inherits the first $200,000 of your intestate property, plus 2/3 of the balance. First $200,000 of your property, plus 2/3 of the balance, and your parents inherit everything else. So this, again, real world situation, precarious situation where now they can be in a feud together. Your spouse might be thinking they're going to inherit all. Your parents may not want anything because maybe they're in a nursing home or maybe on the verge of entering into a nursing home, and now they inherit the balance. And that could put them over asset or could expose those assets to Medicaid estate recovery or liens. Not an ideal situation from my experience, okay? Let's move on here, folks. Parents, if you die with parents but no spouse or descendants, of course, your parents inherit everything. Again, not a great situation. If you have elderly parents and you don't have a spouse or children, your parents are going to get everything first. Again, if they're elderly, that could put them in a not so good situation if they're trying to qualify for Mass Health Medicaid benefits. And now you're going to put them over asset in that situation, okay? Lastly, folks, if you die with siblings but no spouse, no descendants or parents, and then your siblings, of course, inherit everything. Your siblings inherit everything. And a little twist to that, folks, from my experience in the real world, it's not uncommon later in life if you have a few siblings or more and you die, no parents, no spouse, no children, everything goes to your siblings, okay? However, if your sibling or siblings predeceased you, where does their share go? That is correct. Their share will go down to your nieces and nephews, so don't forget them. So folks, there you have it. What will happen to your stuff, your hard-earned assets, if you die without a will? The laws of intestacy will control, or the laws of intestate will control. You have what I refer to as the government plan, and the government plan will dictate who gets your stuff when you're gone. Folks, hopefully this video you found helpful. If so, please scroll down, post a question, leave a comment, and a member of our Elder Law Care team will get back to you at our earliest convenience. Folks, if you'd like to learn more, pick up a copy of the book Four-Headed Monster on Amazon or at elderlawcare.com. And folks, by all means, meet with your estate elder law attorney sooner than later, third quarter of life, maybe early fourth quarter, and put your comprehensive estate plan in place, maybe even a trust-centered plan in place so you can avoid what I refer to as the four-headed monster altogether. Slay the beast. Folks, Elder Law Care attorney Patrick Kelleher, thank you for joining us here today at elderlawcare.com. We will see you next time.